So we now proceed to plenary session 2, which will delve into protecting the vulnerable, the role of the Ombudsman in upholding human rights. I'm pleased to introduce our moderator for this session, Mr. Matthew Xuereb, Editor-in-Chief of RTK 103 and newsbook.com.mt. And I invite him to guide us through the discussion.
Good morning and thank you. Our first speaker today, before I introduce the rest of the panel, is Judge Lorraine Schembri Orland, who has an important court session that she has to attend to. So she'll be delivering her speech, and then I'll invite the rest of the panelists because Madam Justice needs to leave.
Good, so thank you for that. I know, yes, I know.
This is on.
Yes.
So, first of all, I would like to apologize in advance. I'm on a remote session with the Grand Chamber, and they suspended until I go back, so I'm very sorry. Honourable Parliamentary Ombudsman of Malta, Judge Joseph Samit McKeon, a colleague and a friend, honourable members of the Ombudsman's Office, and distinguished guests. It is indeed my pleasure and a privilege to participate in this seminal conference, which has brought together the Ombudsman, Ombudspersons, and representatives of human rights institutions from across the globe. My goal is to highlight the dynamic link between the office of the Ombudsman and the role of the court, within the overarching theme of good governance and protection of the vulnerable. The European Convention sets the benchmark, the minimum standards for states on human rights. To my mind, the Office of the Ombudsman holds the Convention as a mirror to the authorities, to state officials to bring them to account. The Convention is a treaty for the collective enforcement of human rights, and our judgments, the judgments of the European Court, are enforceable. So, the powers of the Ombudsman may vary from state to state, but as an institution, there is no doubt that it is an independent gatekeeper for safeguarding human rights and plays an essential role in instilling a human rights dialogue and understanding at every level of society. In this respect, it shares a common goal with the European Court, which is the effective protection of human rights. Help, which is the button. Yeah, this is, okay. Yep. This is a quote from Selahattin Demirtas number 2, a leading Grand Chamber case, which highlights the rule of law. And this year marks the 75th anniversary of the Convention, and the three foundational principles of democracy, fundamental human rights, and the rule of law are facing serious challenges. There is nothing new to say that arbitrariness is the antithesis of the rule of law and the negation of fundamental human rights. Taking this one step further, these three foundational values are mutually reinforcing, and democratic backsliding can turn to persisting structural human rights challenges, a deterioration of the rule of law, and a shrinking civic space. They are links in a chain. Break one link and the chain falls. It is consequently not surprising that the rule of law is at the forefront in the court's interpretation and application of the Convention, particularly with respect to systemic violations. Notably, the court has dealt with democratic backsliding in the Polish judiciary rule of law cases. Thousands of cases have come before our court in the aftermath of the attempted coup d'etat in Turkey. These cases concern Article 6, fair hearing, Article 7, no crime without a law, no punishment without a law, non-retroactivity of criminal law, impeos, to the harm, to the detriment of the accused. The requirement that according to law, the law has to satisfy conventional requirements of foreseeability, clarity, and access. So all these reinforce the rule of law as a bedrock of human rights. And it has been said that the rule of law is a methodological point of departure in the reasoning and analysis of the court. The Ombudsman plays an essential role in strengthening the human rights architecture in a country. The investigations of the Ombudsman provide an additional direct on-the-ground assessment of the facts and practices applicable to human rights complaint. So in the short time allotted, I can only provide broad brushstrokes. And the protection of the vulnerable under the umbrella title of good governance is significant. There cannot be a more forceful proposition to ensuring good governance than to ensure human rights protection to those who, because of their age, capabilities, and status, find themselves bereft of rights. This one? Okay. Article 1 of the Convention places a primary obligation on states to protect human rights of all within their jurisdiction. Now, this is not just a duty not to interfere, but it is a positive obligation to do what is necessary to protect and effectively safeguard human rights. This is the flip side. To protect against impunity, intolerance, hate, and discrimination. Vulnerable persons do not normally have a strong voice and require greater protection. So a positive obligation would require states to put measures in play against foreseeable harm, to assess risks, to introduce legislation, protect against discrimination, and procedures for investigating crimes and bringing perpetrators to justice. In the context of hate crimes, there is an additional positive obligation to identify the buyer's motive. And I will just go through briefly some cases where vulnerable persons where violations were found. For example, X and Y, the state was held liable because its criminal law did not provide a means by which a sexual assault on a mentally handicapped young woman could be the subject of a criminal prosecution. Kurt versus Austria, the latest in a series of domestic violence cases, where you have procedural positive obligations, make the risk assessment and preventive protective machinery to protect victims of domestic violence. Incidentally, according to the Convention, domestic violence can amount to torture. Suicide in detention. Detainees, persons in custody, are vulnerable persons. There is a positive obligation. So if the authorities knew or should have known that there was a risk of suicide, procedures should be in place to protect and safeguard against that eventuality. Minor immigrants, vulnerable par excellence, not because of their age, but because of their position, that they are in a different country without their parents, alone, often alone, and with the fear in that situation. In this case, migrants should not be kept in detention, but should be placed in reception conditions catered for their particular conditions and needs. So, the human rights protection of the Convention is obviously extensive. At a domestic level, the Ombudsman does not need to have human rights protection in his mandate. Why? Because a breach of human rights is an act of maladministration. So at this point, the human rights function of the Ombudsman is inherent in the role of the Ombudsman. And I welcome the efforts of Judge Zamit Mekin and the Office of the Ombudsman to try and bring the Ombudsman into the realm of a human rights institution, which to a certain extent it already is, but the vision is bigger. So the principal difference between the two institutions is that the court delivers binding judgments. The Ombudsman does not, normally. But on the other hand, our court cannot start a own initiative investigation, whereas the Ombudsman can. The first issue, but, in an application before the court is admissibility. And here, the issue of the Ombudsman can encounter problems, because to come to a court, the applicant has to have exhausted all domestic remedies, which have to be effective. And if the decision of the Ombudsman is not enforceable because it is advisory, let's say an applicant goes to the Ombudsman with his complaint, but ignores effective domestic remedies and comes to the court directly, hand in hand, the report of the Ombudsman, in all likelihood, that application will be deemed inadmissible for non-exhaustion. And the applicant will have to go through the normal process and possibly come back to our court when all is said and done. However, in one particular case, a Swedish case, Eriksson, after a number of years, the Chancellor of Justice was found to give an effective remedy consisting of pecuniary and non-pecuniary damages. So now, according to the case law, as far as Sweden is concerned, the Chancellor for Justice is a remedy to be exhausted. So if an applicant comes to us and doesn't go to the Chancellor, then non-exhaustion. But what would be the case? This is quite strange. If a person goes to the Ombudsman does investigate, sends the report to the Attorney General does nothing. And this was a case of Egmez versus Cyprus, which concerned police brutality. The court said that it had no reason to doubt the effectiveness of the Ombudsman's investigation, which was timely and led to the identification of the perpetrators. So everything was put in a neat package to go before the criminal courts. But nothing was done. The court held that in this case, by going to the Ombudsman, the applicant had exhausted the effective remedy because it should have normally led to the prosecution of the perpetrators identified because it was an effective investigation. But in this case, nothing was done. So the application was admitted, but on the merits, the court held that by refusing or abstaining from doing anything, the state had failed in its obligation in its positive obligation to take procedural measures to bring the perpetrators to justice. So here we have a bit of a kind of a situation where the recourse to the Ombudsman could, in certain circumstances, be held to be an effective remedy. The interface of the Ombudsman's office with the court comes in many forms. As we said, we would take cognizance of reports, particularly if these reports are extensive, the investigation is good, and the domestic courts have ignored them or have not properly weighed them. The Ombudsman can intervene as a third-party intervener. And for example, in Rantsev versus Cyprus and Russia, which concerned human trafficking, the court cited the report of the Cypriot Ombudsman, which highlighted the systemic problem of trafficking. So, in conclusion, the domestic ombudsman has a critical role to play in holding public officials to account for breach of human rights. And the court will take account of interventions, public reports, investigations, and all this provides an important structural protection for human rights, democracy, and the rule of law. I would like to thank the Parliamentary Ombudsman for Malta again, and the organisers for having invited me to participate in this extremely interesting conference. I regret I'm not able to stay, but I have a primary duty which I have to put into effect. And I wish you all a fruitful discussion and a pleasant stay in Malta. And thank you. Thank you.
So thank you, Judge Schembri Orland. Wish you good work, as you say. So let me invite the other panelists. Deputy Commissioner for Human Rights of Ukraine, Mykhailo Spasov. Marina Ceyssac, High Commissioner for Protection of Rights, Liberties and Mediation in Monaco. Dijana Možina Zupanc, Deputy Human Rights Ombudsman of Slovenia. Tamar Gvaramadze, excuse that pronunciation, First Deputy Public Defender of Georgia. And Andreas Accardo, Head of the Institutional Cooperation and EU Charter Unit. So thank you for joining us. So this panel is going to address the crucial dimension of the Ombudsman's mission. After listening to all the speeches this morning, allow me to a small comment from my part, also as president of the Institute of Maltese Journalists. The similarity between the Ombudsman's mission and that of the media in seeking the truth, in exposing the truth. And I think even we heard from our speaker, many of the reports get ignored. I think the Ombudsman's offices collectively need to use the media and social media to get their work out there for people to appreciate what's being done, and also to convince others to come forward and report any injustice that they're facing. The Ombudsman's institutions play a vital role in offering accessible mechanisms and uphold human dignity. By investigating and promoting reform, Ombudsmen translate human rights into everyday practice. Judge Zamit McKeon is one of those advocating in Malta for the setting up of a national human rights institution, something that exists in many countries. This panel will examine how to serve best vulnerable people, whether migrants, minorities, persons with disabilities, or the elderly, through complaint handling, advocacy, and partnership building. One of our first speakers today, apart from Judge Schembri Orland, was meant to be Debbie Kohner, Secretary General of the European Network of National Human Rights Institutions. Unfortunately, due to a flight strike in Belgium, she was unable to join us in person, but she has prepared a video message to share her insights. Let's watch her message together.
Congratulations to the Office of the Parliamentary Ombudsman of Malta. 30 years is a huge milestone. I dearly wish that I could be with you there in person, but sadly a strike at Brussels Airport has prevented me from travelling, and I'm delighted that I can at least speak with you through this video address. This brief intervention will look at the role of the Ombuds institution in protecting the rights of the vulnerable. And I know that I am not alone in stating what a vital actor Ombuds institutions across the world are in protecting those in a vulnerable situation. Through Ombuds complaints handling, investigations, and many other functions, they truly are indispensable in our overall democratic infrastructure. Now, traditionally, the Ombuds institutions work on maladministration. However, they are increasingly seen as human rights bodies. Now, this might be due to a broader mandate, such as being designated also as the National Human Rights Institution. It might also be that a traditional Ombuds institution applies its work with a human rights-based approach. And finally, under the EU Charter for Fundamental Rights, it could also be that the Ombuds institution is working with the fundamental right to good administration within the scope of EU law. Whichever of these, we know that Ombuds institutions do support and protect the rights of those in a vulnerable situation. Now, I'd like to consider beyond that the broader national infrastructure for human rights protection and the fact that there are also other national bodies working on human rights alongside the Ombuds mandate. Now, first of all, we can consider the National Human Rights Institution, or ENNHRI. A National Human Rights Institution is different to an Ombuds institution mandate insofar as it has a very broad human rights mandate, looking at all human rights across all of the conventions, internationally and regionally. Further, they have very broad functions to both promote and protect human rights. And this means that while they may not always have complaints handling functions, they do always monitor the human rights situation in the given state. They report to international and regional mechanisms. They promote human rights, and this mandate helps to raise awareness and create a true culture of rights. And finally, they must work closely with civil society. Now, we have other national mandates that we can see that might be in the same institution or in a separate institution with cooperation between them. For example, we have the Equality Body mandate working under the EU Equality Directives. Beyond that, specific mandates exist in relation to the rights of persons with disabilities, unauthorised access and monitoring of places of detention under OPCAT. We also have mandates looking at anti-trafficking, looking at forced returns, looking at slaps, whistleblowers. There are many. The most recently recognised in Europe are those coming from EU legislation, looking at compliance with the EU Charter in relation to EU structural funds, in relation to human rights at borders under the screening regulation, and also under the EU AI Act, where NHRIs or ombuds or equality bodies might, or all three in fact, might be designated as protection bodies. Now, each of these national mandates, of course, work with human rights. Each of them is distinct, but they are very much complementary, and it's important that there is effective integration or cooperation so that they work together in a more seamless, coherent and comprehensive human rights protection architecture for the state and, most importantly, for individuals within it. Now, one mandate, a national mandate that Malta does not have in law is that of the National Human Rights Institution. Now, this sadly goes against international commitments. It has been called for by the UN, the Council of Europe and the EU. NHRIs have been recognised as essential parts of the checks and balances, as filling the protection gap between the state and the individual, as being a safeguard for rule of law and also for supporting civil society space. Now, in these difficult times that we are facing, it is particularly important that an NHRI is established in law by Malta. This not only will fulfil the international commitments, but it will also end the situation where it is one of only 3 EU member states that has not completed this final step. So ENNHRI stands ready to support Malta in the establishment of an NHRI in law. And until then, I would like to send yet again my hearty congratulations to the Ombudsman of Malta, to all those who are working in his team, and to all those who have worked there over the last 30 years. Wishing you all the best in your celebrations and looking forward to working with you across the decades to come. Thank you.
Thank you to Debbie. Hopefully a political commitment about the establishment of an NHRI will happen at the end of this conference, by the end of this conference, hopefully. Can I now invite Mr. Spasov, Deputy Commissioner for Human Rights in Ukraine, who will share his insights shaped by the challenges of safeguarding rights in times of conflict.
Thank you. Good afternoon, dear colleagues, distinguished guests, partners. Before I start, I would like to congratulate our friend Joseph Zamet Makian for this 30th anniversary, and again, it's a great privilege and a great honor to share this day with you. Unfortunately, Commissioner Lubinets couldn't make it here, but I will do my best to highlight you with what actually our office is doing during these hard times of war in Ukraine. So for almost 11 years, Russia has been the biggest violator of the human rights in Ukraine. And every day its aggression takes the lives of civilians and destroys the faith of thousands of Ukrainians. And of course, their protection is at the heart of our mandate as an ombuds institution. During the full-scale war, we reformed the institution of Ombudsman of Ukraine and established 9 core areas of our work. One of them is the rights of citizens affected by the armed aggression against Ukraine, which is of particular importance in the context of war. And other areas include the rights of child, social and economical rights, rights in the security and defense sector, equal rights and freedoms, rights of national minorities, political religious beliefs, human rights in the places of detention, the national preventive mechanism, the informational rights, the rights to fair trial and representation in the court system of Ukraine, and of course international cooperation and European integration. Due to Russian aggression, the number of the appeals in the Office of Ombudsman has increased significantly. As you can see from this slide, in the first 9 months of 2025 alone, more than 100,000 appeals have already been received. For comparison, in 2022, there were only 42,000 of such appeals. In 2023, there were almost 96,000. And in 2024, you can see there were over 123,000 of the appeals. Every day, Russia attacks civilians. Children are the most vulnerable as they cannot protect themselves. As of October 8, 2025, 658 children have died as a result of the Russian aggression. And the youngest one was only 2 days old. The child died as a result of the shellings of the maternity hospital in Zaporizhia. On the other hand, Russia has been deporting Ukrainian children since 2014, when the Russian Federation launched its war against Ukraine by annexation of the Crimean Peninsula. At the same time, the threat remains enormous, and during the full-scale invasion alone, approximately 20,000 of cases of the deported children have been verified. And on the other hand, Russian side themselves claim that 700,000 children have been abducted, or as they call it, saved from Ukraine. More than 1.5 million children in the temporarily occupied territories remain in risk of deportation or forcible transfer. During the full-scale invasion by Russia, the Office of Ombudsman of Ukraine took on the new function, participating in the process of returning Ukrainian children who were deported or forcibly transferred by the Russian Federation. And with the help of the President's initiative, Bring Kids Back UA, we returned back home 1,676 Ukrainian children. We also fighting for the unlawfully detained civilians. It's one of the most challenging categories to return, as there is no actual mechanism which is prescribed by international humanitarian law to return them back home. Approximately 16,000 of the civilians have been identified as unlawfully detained by the Russia, and there is confirmation that more than 1,800 individuals currently are being held on the Russian territory. Let us not forget that those horrors take place alongside daily attacks by the Russian Federation on the civilian population wherever they are located. And according to the official statistics by the United Nations, 14,000 of civilians have been killed in Ukraine. And again, this is only the confirmed figures. So far, only 372 civilians have been returned back home. They are volunteers, doctors, journalists, and public figures, and some of those released have been already held in captivity since 2014. So you can imagine the strugglings and the actual cruelty for the relatives of those people. Those who managed to be returned tell the horrific stories about the torture, and we must immediately do everything to return the civilians back home. Unfortunately, these are not only crimes committed by the Russian Federation. Ukrainian prisoners of war suffer on a daily basis and being subject to systematic torture and humiliation. And again, in accordance to the United Nations statistics, 95% of the Ukrainian prisoners of war have been tortured in the Russian captivity. These are also reports of the systematic execution of the Ukrainian prisoners of war, and as of today, the amount of 268 Ukrainian soldiers have been officially recorded as executed by the Russian counterparty. The Office of Ombudsperson of Ukraine is involved in the process of exchanging of the prisoners of war, and as of today, we have managed to bring home only 6,235 prisoners of war. Therefore, we need to do, and we need to do it as soon as possible, because people, as I said, are only under constant torture. Protecting the rights of veterans is other priority of the work of our office in the terms of war, and most often veterans complain about the delays in processing and review of their documents, difficulty in confirming their status as combat veterans, and inadequate access to medical service. We're seeing a steady increase in the number of appeals to our office. In 2024, there were 1,033, and in the first 9 months of this year, already 1,487. This indicates that there are more problems, but at the same time, it is showing trust in the work that our institution is doing. Internally displaced persons also require special support, and again, there are 4.6 million officially registered IDPs in Ukraine. Of these, almost 900,000 are children and 1.3 million are pensioners. Russia illegally issues passports to Ukrainian citizens that are currently on the temporary occupied territories of Ukraine, and the lack of Russian documents makes it impossible for those people to receive medical care, social service, or any other kind of support. In addition, Russia puts pressure on the parents of the children, threatening to deprive them of the parental rights and to refuse to accept the documents the aggressor, if they refuse to accept the documents of the aggressor country. The Ombudsman's Office initiated the adoption of minimum standards for the functioning of the temporary accommodations facilitation for the internally displaced persons, and since September 2022, our office has conducted 3,373 monitoring visits to the temporary accommodation facilities for internally displaced persons. This resulted in 7,941 recommendations. Russia deliberately targets educational and medical institutions, violating the rights to health care, to work, to property, to culture, and to education. As of today, you can see the numbers. 4,139 educational institutions have been damaged by constant bombing and shellings, and 2,384 medical facilities have been destroyed or damaged. All this is being done systematically by the aggressor state, and each strike is a violation of the human rights in the view of the modern world. Also, Russian encroach on freedom and the rights to worship by destroying the religious sites, and again, as of today, 613 such sites without connection to particular religion have been destroyed. Despite the ongoing war, the issues of combating human trafficking remains relevant, and on the contrary, citizens who are vulnerable is at the risk of exploitation, and this risk increases each day. In 2024, there were 182 reported cases of human trafficking, and in the first 9 months of this year, 171 cases have already been recorded by our office. Also, war increases the people's vulnerability and existing social problems. One of those, of course, is the domestic violence, which, despite the war, is not only disappearing, but on the contrary, is growing on a high scale. In 2024, there were 1,081 reports of domestic violence, and in the first half of this year, already over 61,000 reports were recorded by our office. This year, 243 victims of domestic violence addressed our office, and this number is comparable to 157 in the previous year. Also, conflict-related sexual violence is one of the war crimes of the Russian Federation, and we are addressing those cases on a daily basis. The armed aggression of the Russian Federation is a challenge for representatives of national communities, national minorities, and that is where we're doing our best to help them. in order to finish my speech, sorry, a lot of happening in Ukraine, and that is really the scene where we want to provide this information. Therefore, what I urge, a lot has been said about the courage. I can reassure you that the Ukrainians are fighting with courage, and we will continue to do so. But in order to win this cruel war, we really hope and really need the support of each and everyone who are present here. We value that you are with us, and please continue to do so. Sorry for my emotions, but at the end of the day, we're not fighting for land plot, we're not fighting only for sovereignty, but we are fighting for the protection of human rights of each and everyone. Thank you.
Thank you very much for that interesting presentation with very worrying numbers. Our next speaker comes from Monaco, Marina Ceyssac, High Commissioner for the Protection of Rights and Liberties in Monaco.
Thank you very much. Good morning. First of all, I wanted to thank again our colleague, Judge Joseph Zamir McKeon, for his invitation, his welcome, and also I wanted to thank all his team that is so welcoming and friendly, and I wanted to wish all of them a very happy anniversary of their institution. I wanted to share today the experience of a small institution, which is the institution of Monaco, but our institution is a proximity institution, so we have a very close experience to the field, and we thought that it would be interesting to share it and maybe to find more general consideration from our specific experience. So our experience is that we work with a very broad variety of individual claimants, including persons with disabilities, elder people, prisoners, women in precarious situation, sometimes victims of violence, and we also have the competence for children. And so we noted through this, addressing this various public, that the protection we can offer can take different forms. First, it involves providing support to a vulnerable person in order to resolve individual administrative problems, such as adapting social housing or access to certain social services. It can also involve combating wider discrimination, such as gender inequality, accessibility for disabled persons in general. And this we do also through the notice we issue about law bills that is in our competence. So we issued notice about sport, indemnization of victims of penal infraction, penal procedure, palliative cares. So it's very broad and general. So through this action, I wanted to share that we noticed some specific difficulties. So one of particular difficulties is that certain laws or regulation, as well as certain technical developments, can indirectly and unintentionally lead to discriminatory situation. And these situations are very difficult to predict and resolve in advance. For instance, we had problem with nomenclature of medical acts, some private regulations such as condominium regulation in application of the law, or technological evolution such as touch terminal that were considered to be a progress, and that's very interesting in general, but there are problems, for instance, for blind people. We also noticed the cumulative nature of certain vulnerability factors that place some individual in very specific and simultaneous difficulties that requires a comprehensive analysis of the situation. In many cases, this person face concomitant administrative difficulties, such as access to court, work permit access, housing access, and unfortunately, the compartmentalized nature of administration often prevent a global approach of their situation. So we noted that it becomes essential to adopt, in many cases, a cross-cutting approach, both in terms of the issued address, but also in cooperation with the institution and entities concerned, including, of course, the administration, but also association and civil society, with which we try to cooperate a lot. From a more practical point of view, we also noticed that special arrangement and precaution are necessary to ensure the proper conditions for receiving and engaging a dialogue with a particularly vulnerable person. And so from a very concrete point of view, in our own premises, we are now installing a system of magnetic loops in order to allow people who are deaf, who have a problem to understand, to communicate with us more easily. We also stress that institutions such as prison or psychiatric hospital must be particularly subject to constant attention. And I would like to conclude from a more general point of view, and also taking into account what all the previous speakers said, because it's interesting, I think, to have a kind of dialogue. I think that the relationship with vulnerable person is very important for ombudsmen, because it offers them the opportunity to show that they can be trusted and they serve all categories of citizens. Because any of us, whatever his community, his group, his political preference, any of us can find himself at a point of his life in a situation of vulnerability. And so I think that addressing vulnerability is a very good way for ombudsmen to fight polarization, as we said before, and to stand from a political standpoint, which I think is important to keep the truth of the public and to be able to have a dialogue with every part of society. Thank you.
So thank you, Ms. Ceyssac. Our next speaker is Dijana Možina Zupanc, Deputy Human Rights Commissioner of Slovenia.
Oops. Thank you. First, sincere congratulations to our lovely host for both, for the excellent conference and also for the anniversary, of course. At the very beginning, allow me also to thank all of you for this warm welcome for me personally in this highly respected forum, and for giving me the opportunity to share some thoughts. At the beginning, I have a bad and a good news. I'm going to start with a bad one. I don't have the PowerPoint presentation, so you're stuck with me for the next few minutes. And the good one is that I'm going to be a bit shorter, because so many really excellent points were already emphasized in this and previous panel, and of course also with the introductory speeches. So, about the topic, Allow me to start that in today's fast-moving world, it often feels that the goal is to put ourselves first. From childhood, we learn how to compete, how to stand out, how to chase our own success. And this digital age that we're living in, with its endless screens, notifications, and parallel realities, we sometimes live in a completely closed bubble as individuals, which, of course, leaves vulnerable people even further behind, even more isolated. And therefore, with all this noise going on in the world, we must not forget that empathy, care, and respect for each other are not luxuries. They are the very essence of humane life, in which all steps matters. Whether it is listening and pausing when the neighbor is telling us his story, whether it is holding the hand of the elderly person that perhaps feels invisible, or acknowledging a child who longs to be heard. Educational system, public discourse, and media have not just the power, but also the obligation and the responsibility to nurture this awareness by telling stories of care, solidarity, and also shared humanity, rather than just conflict and sensations, as we are often witnessing. Our role, the role of national human rights institution and ombudsman, is to ensure that no voice is left unheard, as we often heard it today as well. Protecting the vulnerables is not just a matter of policy, it is our moral duty. We have independence, legal, operational, financial, and that allows us to confront inequality, advocate for systematic reforms, and also to speak out to power without fear. Our recommendations, even though not legally binding, can have a significant impact on institutions, on individuals, of course, when they decide to listen. But we are not merely complaint handlers. We saw that one during this morning discussion. We walk the corridors of the institutions. We sit with those who feel forgotten and bear witness with the consequences of inadequate care. We also see the courage of those who survive neglect and the resilience of those who society so often overlooks. So, when the question, what is our future role as institution occurs, I think that the answer echoes with clarity. We have an even greater role tomorrow than we have it today in this changing world. So therefore, there's a huge task in front of us. Safeguarding human rights means safeguarding the very conditions of life, the stability of societies, peace, and healthy environment. And when talking about environment, let me say this and go maybe further from the discussion before. Climate change is surely one of the human rights crises, and also it is one of my biggest concerns. Regarding the vulnerable people, no doubt about it. Rising heat, floods, droughts, they are already endangering health, security, and dignity of so many people. By 2050, more than 216 million people could be displaced because of the climate change. This is the violation of human rights without no doubt. And while the vulnerable, such as elderly, for example, who are even today often energy poor and isolated, remain in those situations even further behind. The Swiss climate change case confirmed that insufficient climate action violates human rights, yet promises, like the Paris Agreement, are fading. And not just that. At the same time, around 70 armed conflicts are going on around the globe. And they are devastating lives, as we heard from the previous Ukrainian colleague, and I'm sure that many of us felt that punch in the stomach while listening to that intervention. We have to be aware also that not only huge and so difficult topics that were addressed, we are also talking about fueling 6% of global emissions, binding war and climate change into this circle of destruction. And ladies and gentlemen, I am in some moments without words. My husband wouldn't agree, but it is. This is one of those moments when we are speaking about this kind of human rights violation. But to sum up, even as institutions, we have to be optimistic and we have to fight. We are late, but we are not too late. There's still time to expose the shortcomings of state actions, to raise awareness of the right to a healthy environment, and also to demand ambitious and just climate policies. We often answer only with reports, statements, and carefully phrased concerns. But the question is not only whether our institutions endure, but whether they really help society rediscover empathy as a strength. Our responsibility is to ensure that behind every statistic, every complaint, and every policy, there remains a human face that is heard, seen, and respected. So we cannot allow ourselves to become comfortable in so-called new reality. Institutions like ours were not created to echo politics, but to challenge it. We are not here to be the guardians of the procedure, but we are here to be the guardians of conscience. And conscience often demands more, as we heard. It has to be connected with courage. If we act only within the safety of the traditional framework, we will always be one step behind, because, as I said it, the world is changing faster than our institutions. Therefore, our suggestion from Slovenian side to remain relevant as institution is, we must dare to think beyond the familiar. We must question old approaches, we must embrace innovation, and we must stand uncomfortably close to the truth, even when it disturbs the one in power, or even when it disturbs ourselves. And to conclude, this is the test of our time, whether we will be remembered as institutions that reacted politely or institutions that acted boldly. I often say human rights cannot be defended by words, but by courage. We will live, well, I will stop at this point and I will say, because I'm hoping for some discussion, let's act strongly, let's be actively in the future, and let's be remembered by the institutions that transformed competition into compassion and power into protection of every human being. The choice is ours, and I'm sure that history will not forgive hesitation. Thank you.
Thank you, Dr. Dijana. Our next speaker is from Georgia, Dr. Tamar Gvaramadze, okay, First Deputy Public Defender of Georgia.
Thank you so much. Good afternoon, everyone. Dear colleagues, dear ladies and gentlemen, dear friends, if I may. It is my true pleasure to be here and join you in this inspiring environment. I'm delighted to join you not only as a colleague, but I guess as a partner in our joint mission for continued success protecting human rights all over the world. Allow first of all, of course, I have to do, it's a must, to congratulate our dear host, Parliamentary Ombudsman of Malta, on the 30th anniversary. I guess it's really significant milestone, and I wish for continued success with the entire team in your work, what you fulfill in every single day to benefit society and the interests of this country. So again, congratulations. Also, I would like to thank for organizing and hosting us in this beautiful sunny place. And the warmth of your hospitality, I guess, perfectly reflects the spirit of the solidarity that unites all of us here in this environment. Protecting the rights of vulnerable groups, I guess it is one of the major functions and core missions of all human rights institutions throughout the world. But I think that the scope and the scale of our work is really impacted by the power we are granted in our legislations and based on our founding laws in different legal systems. Secretary of ENNHRI, Debbie, was talking about and reviewing the different functions of different institutions. She was describing the functions of national human rights institutions, of ombuds institutions, talking about of multi-mandated institution or single ombuds institutions. And the Georgian experience is exactly being a multi-mandated institution. We are ombuds institution responsible to oversight the maladministration, but at the same time we are national human rights institution. We are also granted the power of MPM. It means that we oversight all closed institutions in the country. We are also nominated and fulfill the functions of equality body. We are monitoring body for CRPD convention. So a lot of functions are gathered under one umbrella institution. And we, of course, investigate individual cases of violations. We conduct our preventive work under these different mandates. We compose and address with different recommendations to different state institutions. And, of course, we produce one of the most important documents. Every year we submit our annual report to the Parliament of Georgia to describe the latest developments of human rights in the country and present our recommendations about different issues and different policies. So I guess this being a multi-mandated institution, to other colleagues also maybe they agree with me or not, but it is not an easy task. We are proud to talk that we are multi-mandate, how much power we have, but it is very difficult to fulfill all these mandates simultaneously because there is a lot of debates and discussions, whether it's some power is overlapped in other. For example, if you are MPM, so how it correlates with your function being monitoring mechanism or CRPD, for example. If you are a typical ombudsman responsible to oversight human rights situation in public institutions, but when it comes to equality body, how to deal with this strategic communication with the private sector, because you are also responsible to oversight situation in private sector, etc. So there is a lot of debates about being a multi-mandate institution, but at the same time, of course, it's a huge privilege, because sometimes interpreting and use the interpretation of your different mandates, you can benefit and be more effective to support and help your beneficiaries. I will bring some examples from our work. For example, the one biggest kind of group of our beneficiaries is the prison population. Overcrowding is one of the hugest problems in the country. So fulfilling effectiveness or being effective MPM monitoring body is really very essential in such a context. So we are conducting monitoring visits throughout the country, reporting the violations of inhuman treatment or degrading treatment, and address with the recommendations to the parliament or other state institutions to improve the situation in closed institutions, but instead of just describing problems on a systematic level, being an MPM gives us opportunity to take cases of individual violations from different closed institutions from which people cannot approach us. So we use this proactive kind of own initiative power to initiate investigation of individual cases from the prisons, and vice versa. We receive a lot of applications from prison population, and after discussing and reacting on each and every application, we can see the general trends throughout the country in closed institutions, and of course we can take then those questions into account while planning our MPM work and while addressing our problems. For example, also, it was really very first time we had this observation from prisons last year. We received several applications indicating about the alleged violation of labor rights of inmates. And it was really very first time anyone started complaining about violation of their labor rights within the prison system. And it was not the prison staff, it were the inmates. And we, of course, started investigating these applications like an ombuds institution. But then we said that, okay, maybe it's just two persons, found some courage to address and to raise the voices about this problem, but let's see what's happening in general in other closed institutions. And we entered and started organizing the visits as MPM, developed questionnaires, specific questions about this specific kind of topic, and then found out that there are so many problems throughout all state closed institutions regarding and concerning exactly this topic. So it was really very benefited. An example of being more effective while during the using and benefiting from these different functions. I also want to underline and bring the example of the older population of our country. So older population and the older persons, they constitute approximately 16% of Georgia's population. And based on our observation, they face numerous challenges, including high levels of poverty, vulnerability, and exposure to negative stereotypes and age discrimination in healthcare, social services, infrastructure, and housing. And most of the services I have just mentioned are provided and delivered by private organizations. And when you are just an ombudsman, it is super hard to go and review the cases in private sector and identify the violations of such kind. So we thought and we decided, since we are ombuds, we are equality mechanism, we are MPM, okay, let's go to the closed private long care institutions, maybe like an MPM, but it's okay, it's a question mark if MPM can do that. But we said that since we are also an equality body, in order to identify alleged cases of discrimination, we have to go there because it's long care institutions, it's closed, and older people cannot go outside. They can't make any communication with us. So let's do it proactively. Visit them, identify the cases under different heads, let's do our job in the best way we can. And we did that, and we found several and serious challenges in several closed institutions, for long care institutions for older persons. And we managed to deliver and observe, to share our observations to the parliament, to relevant state institutions, and then drafted relevant recommendations to improve the practices. So these just two examples, I guess, show that it is so important to use all the tools in your hand. It's really difficult, I can understand again, because it's a lot of legal debates and disputes about this issue, but I guess it's really very important for the beneficiaries and the citizens of our country. They don't think so much about these legal details and disputes, it's only our job, but for them it is important to have really effective ombuds or an ENNHRI or equality body, to have some trust in the institution that someone will look for your case and review and find some solution. So just to finalize my contribution, I can say that working with these diverse, again, groups under different capacities and mandates is complex and demanding task, but the broader the mandate and authority we have, the greater our ability to fulfill our core mission, protect of human rights and ensuring that no one is left behind. I thank you.
Thank you very much. Thank you, Dr. Tamar. Finally, Mr. Andreas, we're running approximately 15 minutes behind schedule. If you're a bit short, we might have some time for some interventions from the floor.
I understand the subtle comment. So I hope, in the interest of time, it's okay that I skip greeting all the dignitaries, dear participants. But I still, one word just to thank Joseph and his team for inviting us to this anniversary, and congratulations to the 30th anniversary. I think the way how your team has been organizing this conference shows the strength of the institution. You have a very professional and friendly team. Many thanks for that. For the EU Agency for Fundamental Rights, where I'm coming from, it was particularly important for me to be here for your anniversary because we consider national bodies competent for human rights, ombuds institutions, equality bodies, ENNHRIs, as our closest partner in order to protect fundamental rights in the European Union. So many thanks for the invitation. I'm also humbled, I must say, by the fact to be here on the panel with Mykhailo. Thank you for sharing the suffering of your people. It was always very touching when I listened to you and Dimitro, and I just want to say that I'm very humbled by speaking after you. The title of our panel is Protecting the Vulnerable, and I want to start with those we're here to protect, so the vulnerable. As you know, the Fundamental Rights Agency is doing a lot of large-scale surveys of minority groups in the European Union, and we have amassed massive evidence, let's say, about the lived experiences of those vulnerable to rights violations. Our surveys sadly show that many groups face very high rates of discrimination, harassment and violence in the European Union. LGBTI communities, migrants, Roma people, black people, but also children and women who become victims of violence. I want to name just one figure from a recent FRA survey, which is called Being Black in the EU, just to note the scale of rights violations we're talking about. 47%. This is the EU average for the number of black people of African descent who said that they had experienced some form of discrimination in the past 5 years. In one member state, it raised up to 76% of the black people who faced discrimination in the last 5 years. It's Germany, by the way. But I want to focus here less on the prevalence of rights violations in our society than more about what we can do about it. For this, I want to dwell on one of the recurring themes of that cuts really across all our surveys, which is the low level of reporting of violations. And that comes to the core of let's say, the responsibilities of various complaints mechanisms, including the ombuds institutions. We normally ask whether people who have experienced rights violations, whether they have reported these incidents to one of to any of the competent bodies. And we also ask them, if you didn't report it, why didn't you report it? And the majority of people say, it's because I believe that nothing would happen if I report it. And of course, any act of violence, of harassment and discrimination that does not get reported, it means that it will not be punished. And Irinda, to quote you, the law in the books will not become the law in practice. This is why it's a reason of concern. Let again give me one figure to underpin this with evidence. Only 11% of LGBTIQ people, and this is an EU average, who said to have experienced discrimination reported this incident. 11%, so 1 in 10. And by the way, in Malta you can take pride in this statistic because you're topping the EU list with 20% reporting of amongst the LGBTIQ people. At the same time, I must tell you, and by the way, it's in some countries it's as low as 6%, 5%, Poland, for example, 5% of LGBTIQ people only reporting incidents of hate to the police. But Malta, I'm afraid, in terms of reporting to the police, just marked as badly. Only 8% of LGBTIQ people that have experienced violence, sexual violence or physical violence have actually reported the case to the police. I'm saying that, and by the way, I could also quote a bit more depressing statistics about the awareness amongst vulnerable groups about various redress mechanisms. And Margaret, I'm afraid you're not alone. And it was very inspiring, really, listening to you, how you are making an effort to reach those most disadvantaged, most deprived. But I'm afraid that across the board, it is an issue that those that we are there to serve, where we want to help the most, are also the ones that are least aware of our existence. So as many people at the conference said, ombuds institutions, they act as the impartial mediator between the people and the government. I think the Ombudsman of Turkey, if I may quote you, you called it, building if I get it right, build a bridge of trust between citizens and the state. And I love that, in terms of a picture. They help the state to deliver on one of its core duties, that is to secure redress and to deliver justice to those whose rights have been violated. From a victim's perspective, it cannot be overstated that approaching an ombuds institution is much less intimidating than going to the police or to the court. This makes your role so important. So we heard a lot at this conference about the important role that you play, and I can definitely relate to that. The Speaker of the House even called you democracy's last line of defense. I thought that was quite a responsibility that you have. I'm afraid I need to add another task to your list, and that is that you really have to help us curb the disease we have in society about the underreporting of violence, of harassment, of discrimination. We need to make progress on that those people that are experiencing that partly on a daily basis are encouraged to report those cases to bodies that can help them. But the good news is, and I think, Joseph, you know that very well, you're not alone in that. You have brought together all these partners and friends here, and in fact, in any human rights institution needs very strong allies. The under-resourcing of human rights protection is endemic. Some people may say it's even politically desired. That means that we really need to work with others. We need partners to help us fulfill our mandates. When my team at FRA tells me that we are 100 people only, how can we protect 500 million, the fundamental rights of 500 million people in the European Union, 27 member states, 3 candidate countries with 100 people. I always quote to them a figure that our director, Sippa Rautio, who used to be the director of the Finnish ENNHRI, once told me. 3,000 people. 3,000 people work in national human rights institutions across the European Union. Add to that ombuds institutions, equality bodies, the Council of Europe, ECHR, judges. Think about what a massive human rights expertise we have in Europe, and if we were to work together on those issues. So let me conclude by just saying why one group maybe that I felt we could have talked a little bit more in terms of partner, and that is civil society. I do think that for any complaints body, it is crucially important to work with civil society. Why is that? I mean, one is, you've talked, Margaret, about how you're working in Northern Ireland with civil society to reach vulnerable communities. That's definitely one important role. You know, raise rights awareness amongst those we want to reach. Another important role, I think, for civil society, or contribution for civil society, is to provide you with some contextual information to understand if you're dealing with an individual case or with a systemic issue. Of course, Rainier, you're totally right. You have to investigate your own, you have to do your own independent investigations. But civil society can indicate to you what it's worth doing your own investigation into a matter. And then finally, and we have talked about this as well, it's important for civil society to help you advocate that your findings see follow-up by those that need to take action. And they will help you to monitor throughout the process where the governments will actually follow up on your actions. So I think it's important to maybe bring that aspect of a partner that I see a little bit less spoken of, but it would be important to look at civil society. I'm afraid I need to address, in my last words, the elephant in the room, also from the Fundamental Rights Agency's perspective. Malta being one of only 3 member states, together with Italy and Romania, without a national human rights institution. You know, Tamar, you have spoken about how complex human rights mandates become in these days, and they become more and more complex. There be listed all these pieces of EU legislation that are handing out new mandates to national bodies. I believe that a human rights institution, any country that has a human rights institution with a broad mandate, can help in playing a role in coordinating, cooperating, fostering cooperation between different human rights bodies, making sure that nobody falls through the gap. And so I can only, join the chorus of those who have encouraged Malta to follow the European trend, the international trend, and also set up a national human rights institution. And there's no one-size-fits-all across the European Union, but as you know, many member states have followed the example of Czechia now, most recent example, to expand the mandate of the Ombuds institution to include other parts of the human rights promotion mandate to turn the Ombuds institution into an ENNHRI. So I leave that with you, and I look forward to our discussions. Thank you.
Thank you. I think the need for a national human rights institution, the message should be made tomorrow when the politicians are here, because here you're preaching to the converted, I suppose. Unless we have some questions, Judge De Gaetano, yes?
Hello, yes, thank you. Actually, I had a question for my successor at the European Court of Human Rights, Judge Schembri Orland. I didn't realize that she was going to be only a bird of passage at this conference. My point is something that has been raised by the Ombudsman, by Joe, and in several reports, annual reports. I have raised it in academic articles as well, is the question of Protocol number 12 to the European Convention on Human Rights, which Malta signed and ratified in December of 2015. Not signed only, signed and ratified. It came into force on the 1st of April 2016. I don't know whether the date, 1st of April, April Fools, has anything to do with the problem. I don't know, but to date, that protocol is the only protocol signed and ratified, protocol to the European Convention on Human Rights, signed and ratified by Malta, which has not yet been transposed into our European Convention Act, which means that, as Judge Schembri Orland said, if anyone wants to invoke Article 1 of Protocol number 12, one has to go directly to Strasbourg, because our courts, including the Constitutional Court, has no jurisdiction to apply that convention. Now, I don't know why this has happened. More than 9 years, and this has not yet been activated in such a way as to enable everyone in Malta, not only citizens, but everyone in Malta, to invoke a provision of a treaty by which Malta is now bound. So, as the speaker said yesterday in the speech in Parliament, decisions must be transparent. Here we have something, non-action, which to my mind is shrouded in sepulchral opacity, because no one knows why. Perhaps, as Mr. Xuereb said, we might have some good news tomorrow in the second session. Well,
hope is last to die, they say.
Well, the poet said, hope springs eternal in the human breast. You're quite right. Thank you very much indeed.
Thank you, Judge De Gaetano. Yes, we have another question here. Here in the front, please.
Does it work? Yes, it does.
Yes.
So Denis Shimonovic, I'm the Ombudsman of Croatia. Those of you who know me, and all of you actually do, know that multi-mandate institutions is my favorite topic in the world, but I'm not going there. I think Tamar covered it quite well. I had an institution which is a multi-mandate institution, much like that of Georgia. But my question for you today, and I would primarily say it's for Andreas, but for all of you who want to take it up, if we try to connect the first panel where we spoke of the Ombudsman as a pillar of democracy in times of change, and this panel where we were looking at Ombudsmen in upholding human rights and focusing on vulnerable groups, one thing that I'm seeing in these changing times is that we've gone from democracy, the rule of law, and human rights being together to human rights being put, if you will, in a tension or contradiction to human rights. Because people keep saying, well, you know, you as an ombudsman should be protecting us, the majority, our needs, our wants, and yet, as ombudsman, protecting the rights of vulnerable groups, and particularly those multi-mandate institutions which have an equality body mandate, but also an ENNHRI mandate, and I do hope you get it in Malta, really are also about protecting the rights of migrants, of ethnic minorities, of religious minorities, and then we hear citizens and the majority saying, well, you should be protecting us. That's what democracy means. We should be posing the demands. So how to deal with that communications-wise, maybe for Andreas and Fra, who has been pioneering the 10 keys of communicating on human rights effectively, how do we deal with this in these challenging times? And to all of you from national institutions, I'm sure dealing with the issue.
So, microphone, and the floor is yours.
Tina, I wish I had the key to that, to the answer to that. I mean, it's obvious that this is a tension that is right now played out, and we have seen it in the letter of the 9 on when it came to how they were speaking about the European Court of Human Rights, and it's a tension that also we see in the discussions about what's now called the defense of democracy, the democracy shield. Dimitrov, when he visited our institution, he left, I think, a picture that he was saying to me, that how to fight the dragon without becoming the dragon yourself. I think that's important, that we have to, you know, the European Union was built on a foundation. These values are not, let's say, invented. All the member states, by joining the European Union, have signed up to those values. And I think people knew very well what those values were at the time when they were joining. I just have to remember '89 and the democratic changes we have seen there. I think it's the people knew why they were joining the European Union. And it wasn't only the economic benefits and the freedom of movement, but it was also, you know, the promise of freedom and human rights. And it's enshrined in the treaties, and I have no other answer than referring back to what's in the law. I think we need to stick to what's in the law, what's in the treaties, reminding people it's not sent from God. This is what we have, you know, signed up to by joining the European Union, and this is also when in the accession talks where, you know, the European Union is trying to say that the fundamentals is a rule of law, fundamental rights, and democracy. By the way, the tripod is being used sometimes internally. One hears only democracy and rule of law anymore. Human rights sometimes not being mentioned. I think that's something that we have to be very careful about. It's an issue of policy coherence as well, because the EU is quite strong in terms of external relations. Talking about upholding human rights, I think it's also about upholding human rights inside the European Union. So I think there are many arguments that one can make. I would say the strongest argument for me is the law and the fact that it's the foundation of the European Union that we have signed up to. And don't buy into that narrative that values are something that, you know, can be negotiated, and it depends on whoever's in power. I don't think that is what the mothers and the fathers of the treaties had in mind when they were developing these.
Thank you very much. Would you like to add anything? Seems to be on. Yes,
It's on? Okay,
yes.
Thank you. Yeah, I guess it's a question for Emilian, and it's most difficult question to answer, and I guess also for all of us, we will have our own answer, because we are coming from different contexts, and in some countries where we deal with the backsliding of democracy, and where there is so high tension and polarization in society, and everyone expects from you to be part of either group and do more about the political rights or civic rights rather than social economic rights, because they are not a part of political agenda, unfortunately. But as an ombuds institution or an ENNHRI or other type institutions, unfortunately, we don't have such a freedom to choose. We have to fulfill our functions, and in our case, it's oversight human rights situation, and all human rights are important for us. So it's a question of strategic communication with public, dealing with the expectations of the public, what you are expected from others to do, and what is your job, and how you then balance your reaction. So it's really very difficult. We conduct a lot of mistakes, but we have to learn from our own mistakes to improve, and every next step should be bringing more positive developments to our societies rather than negative ones. So it's really very difficult questions, but anyway, thank you so much for asking.
Thank you. Are there any other questions from the floor before Mr. Spasov, we saw your very interesting presentation with those scary numbers. When it comes to the unlawful deportation of children, to what extent did international cooperation play a role in you solving or addressing this issue?
Thank you for this question. Of course, we rely on our international partners in the terms of returning each and every child back to Ukraine. And in that regard, the Coalition for the Return of the Ukrainian Children has been established 2 years ago. Now it consists of 44 members. And actually the results that you have seen on this screen is a result of the common activity in that regard. Plus, we hugely rely on the help of our international partners in the terms of intermediary countries like the state of Qatar, which contributes directly to the return of the Ukrainian children and which has direct communication with the Russian state. And last but not least, of course, is direct communication by Mr. Lubinets with his contract with the Russian Federation, probably the only connection of communication which we have at the moment in order to fulfill our humanitarian obligations. So it's very important to maintain this and to add more and more stakeholders, more and more players to those activities, because in the end of the day, from the number you have seen, even if we will return just one child a day, it will take us more than 50 years to return all of them back home. And if to proceed from the actual numbers, which are still in the temporary occupied territories, we should understand that we might have no future in case we will not get back home our children. Thanks.
Thank you very much. I can assure you, you asked for support before. I can assure you have our support as local media, especially. Dr. Dijana, you spoke about climate change, which is something which I think a lot of people are ignoring. People are not realizing the extent. To what extent can the Ombudsman bring about concrete change in different countries?
Well, it depends on the country, of course, would be the short question. In our case, in case of Slovenia, we have a constitutional right to the healthy environment, which, of course, we as Ombudsman, National Human Rights Institution, we are often emphasizing that if the insufficient action from the state is here, then we are talking about the violation of human rights. It's as simple as that. And it's going to be more and more important in the future because the climate is changing, the devastating situations is bringing along, and we are suffering extreme weather events and other natural catastrophes. We will have to do our job, and that's why I said it. It's going to be even more important to be in our shoes and our institutions in the future. But if I may, I would just like to refer shortly to Tina's question, because it's really $1 million question, and I cannot stop thinking about it. What can we do? Of course, also I don't have the solution, but I'm thinking that those situations when we have the collision of two rights, minority or it doesn't really matter, two rights, that it is also our duty as an institution to be some kind of mediator, to understand that where does my right end and the other's right starts. But what do we need for that? We need respect, we need to be positioned, we need to be accepted politically and publicly. I'm not going to explain about the Slovenian situation right now, because most of you are aware of the problems that we are having with the election of the ombudsman. These are the situations that for sure are not contributing to positioning institutions of the national human rights. Thank you.
Thank you very much. Marina, you spoke about the cumulative nature of vulnerabilities, and you spoke about how you contribute with your opinions on new laws. How do your recommendations turn into effective protection for the most vulnerable?
Regarding to our law notices, what we do when we do notice about law bills, that's your question.
Mm-hmm.
they are not compulsory, but we have noticed that quite a number of our recommendations are taken into account in new laws. And I will join your remark about the cooperation with civil society and association, because we noticed that when we make a recommendation and that this recommendation is in line with the action of association or the civil society, it has more power and it has a good chance to be taken into account, or at least to start a debate. For instance, for the time being, there's a debate about LGBT person rights in Monaco, because there's no problem of hate, of hostility to LGBT people, but our laws, and especially civil law, is not always adapted to that, and so there's a reflection which is very, very complex. And we noticed that cooperating with association, the civil society, we have also a dialogue with the religious institution, with the government, helped that a debate arise about this question. And this debate, it's not ended yet because it's very complex, but it's taking place in very good conditions and very respectful condition, and the opinion of each point of view can be considered in a very peaceful and respectful way. And I think that it's very important. We are, as ombudsman, we don't have all the answer, and we were saying that when there are very complex problems, we cannot magically find a solution that no one found before. But we can help having a peaceful dialogue and have a progress of society, avoiding polarization and that sometimes for political reasons or specific reasons can be researched by certain groups or persons, and we try to succeed in that, and I think that for some debate we are successful in that.
Thank you very much. I will have time for 2 quick fire questions. Andreas, I'll ask you to be short again in your reply. You spoke about, and I quote, depressing statistics, you said, the erosion of trust of people in institutions. What can be done to rebuild this trust?
I actually spoke more about the lack of awareness amongst those we want to protect, but I think it's one step towards that. But I do think that, I mean, a lot of the organizations are doing that already, but showing the effectiveness of the work you're doing, reaching out to those you want to reach, having allies helping you in that, making sure that people know where to turn to, lower the threshold so that people can easily access you. So I think I think the solutions are known. Maybe we have to learn a little bit more from each other. I mean, I learned today from Margaret what she's doing in Northern Ireland. I'm sure, by learning from each other, these meetings, I think it's a very good step forward. And looking, but maybe particularly at that issue, how focusing in on that, how can we rebuild not only the trust but also the confidence, let's say, of victims of human rights, victims of discrimination to address us. I think it's one step in the right direction. And then the more broader question, I think, goes to what we already spoke about. The wider public also needs to have trust in the work we do, and then you replied to that in a way, so I won't repeat that.
Thank you very much. And that brings me to my last question to Georgia. You're also approaching your 30th anniversary since the establishment of the Ombudsman's Office. What lessons can Judge Zamit McKeon learn from Georgia?
Yeah, really very difficult one. Because if you look at the history of our country, how it's moving, changing, and We're struggling with, sometimes it's up, sometimes it's down. Now we're struggling with our backsliding of democracy, shrinking civic space, but the institution is still keep going and functioning and doing its best. So whatever or whenever it comes, it doesn't matter who is in power, what type of institution, or what are the environment around you. You have to do your job objectively, independently, in a very professional way to keep your institution. It's really very essential for the country and for the people living there, because it's maybe only the hope of the people that someone there is a state institution who can help you, who can kind of speak on behalf of you, and and you have to do your best in order to empower the people who believe and trust to you. So it's only the lesson we have learned after 28 years of functioning as an institution.
Thank you very much.
You.
Unless there are any more questions from the floor, I think it's time for lunch. I'm sure all of you are hungry. Thank you to our distinguished speakers, and I wish you a pleasant conference.